So we're very excited. I hope you all have enjoyed the morning panels with this fantastic group of experts that we have here today. And we are fortunate to have another amazing person as our keynote speaker. My name is George Donnelly. I'm a 2L here at Penn Law. And it is my honor to introduce our keynote speaker for this year's Edward V. Sparrow Symposium, Ms. Marcia Greenberger, founder and co-president of the National Women's Law Center. Now, when we chose the topic of the symposium last spring, we had a pretty clear idea as to whom we would invite to be the keynote speaker. The one problem we had with inviting Ms. Greenberger is that we've actually run out of gifts to give her from the University of Pennsylvania Law School. We've given her a clock, plaques, honorary titles. We didn't know how we could top that, so that was really the only thing holding us back, and we got over that hurdle. But the reason she keeps getting invited back to speak and keeps winning awards is because she's the undisputed champion of the women's rights movement over the past 40 years. In an age of cynicism towards the legal profession, Ms. Greenberger is living proof that one person, one lawyer, can create an enormous structural changes to American society and can make a profound difference in the lives of everyday people. If you or a loved one has experienced discrimination during pregnancy, Ms. Greenberger has fought for you. If you or a loved one has not been able to get prescription contraceptive coverage from an employer, Ms. Greenberger has fought for you. If you care about equal pay and protections against sexual harassment in the workplace, Ms. Greenberger has fought for you. Now, you can read more of her bio in the program, but that hardly does her life or career justice. She would like to note there is an error in the program. She did not graduate from the University of Pennsylvania for undergrad. She graduated from the University of Pennsylvania Women's College. It does not have a name like Radcliffe and as Harvard, but she made that very clear. It was the Women's College at the University of Pennsylvania. And I could go on for quite a bit longer talking about her accomplishments and her career, but I know you did not come here to listen to me talk. So I will end with this. Ms. Greenberger, we here at Penn Law are lucky to have you as an alum. We as a society are lucky to have you as a modern-day civil rights leader. Ms. Marcia Greenberger.
Well, who wouldn't come to speak if you get an introduction like that? Oh, George, that was too kind. And I have a 99-year-old mother who lives here, and she would have believed every word of it. But thank you. And it is just such an honor to come during the Sparrow Symposium and have a chance to be back at the law school and have a chance to give this address to you during this Ed Sparrow Symposium. He was a beloved professor at the law school when I was there. And we were so thrilled that he came to Penn because he had already had an extraordinary reputation. And he was just this very much of a dynamic presence in the law school. He was a big man, and you could say sort of a bear of a man, and just open and warm and engaging and inspiring. So just put yourself in my place. If somebody asks you, would you give a address during the Ed Sparrow Symposium, and it's dealing with women's issues, and so here I am, very honored and very grateful to have been asked. Well, let me tell you for 2 seconds just a little bit about me. I graduated from the law school, as George said, in 1970, and I then went to a Washington tax firm, law firm, where I was the first woman associate. And I had grown up in Philadelphia. I went to Penn undergrad, as you heard. I went to Penn Law School. I was so mortified that I would probably never live anywhere else. I thought 1 year away in Washington would be good. And I met my husband, Michael, at Penn Law, and he went for a clerkship on the D.C. Circuit. At that time, there were very few judges who would accept women as clerks on the D.C. Circuit, none yet on the Supreme Court. I was the first woman to be an associate in this particular firm. And it really, as somebody who did not think of herself as breaking down any barriers, there were so many explicit barriers in those days that much as my presentation today might sound as if I am pointing out all of the problems, and as we all know, if you are here today, I know you know, there are so many to be tackled. The progress shows that you can tackle these problems, you can make a difference. It may not be that in a next generation or a generation after they will all be solved, but you really can make an extraordinary difference, and it is so heartening to be in this room with so many people who were dedicated to making that difference today. The center, I began the center in 1972 with as a women's rights project of one of the first public interest law firms, the Center for Law and Social Policy, which to this day, the Center for Law and Social Policy has a focus on poverty issues and is very much inspired by what Ed Sparrow stood for. And he is a hero, and my stock went up dramatically when I told colleagues in Washington that this is where I was going today. Well, the Women's Rights Project came about because the Center for Law and Social Policy wasn't working on women's rights issues, and at the time, law students did not have clinical legal education options in their law schools, and Penn, among some other law schools, sent law students to the Center for Law and Social Policy to get a semester of credit. And some of them were women. And the women law students and the women administrative staff had a revolt at the Center for Law and Social Policy and said, we want more women lawyers hired. We want you to work on women's rights. We want our salary increased because we're getting less pay, because our administrative jobs are women's jobs, and we don't want to serve coffee anymore. So the hardest one, you'll be shocked to know, was the pay part. But I got my job to start a women's rights project because of that activism of women law students, including from Penn, and from the administrative support staff at the center at the time. And my assignment was to see if there was enough work to keep one lawyer busy full-time working in Washington on women's issues. Now, I just want you to know, the question wasn't one more lawyer working full-time. The question was one lawyer working full-time, because there were none. There were volunteers, and there were plenty of efforts going on, but nobody whose job it was in Washington, D.C. to work on women's legal issues. And the issue was, would there be enough work for that one person? And needless to say, it turns out there was enough work. So the center, we became the National Women's Law Center as we grew. We now have about a staff of about 70, and our program areas are quite broad, from education and employment opportunities to women's health and reproductive rights to family economic security, social safety net issues, child care, Social Security, etc. Tax and budget issues and policy for anybody who has taken tax law, and if you haven't, to me it was one of the best classes at Penn I ever had. There's a lot of public policy that's reflected in the tax code, and it's really quite fascinating to be introduced to that fact. Well, Ed Sparrow gave his life, as you know, to the cause of applying the law to support those who are the most oppressed economically, the most disadvantaged economically, and those who are poor and limited in their life options because of the economic struggles that they have to contend with every day. So I wanted to talk a bit about some of the specific work that my National Women's Law Center is focused on right now. And with the topic of this symposium, women's rights, why do they still matter? I decided to take that topic in good stride and in good spirit of why it still matters, given that the majority of the poor in this country are women. and certainly women and their children. Women are still, with all of the glass ceilings that have been broken, the ones that are at the bottom of the ladder. And when you add race to the equation, women of color are at the very bottom. So I thought I would just give you a few statistics about why this focus on women that is a reflection of this symposium is so appropriate, as so many of the panels I've already discussed. But so women are 2/3 of minimum wage workers in this country today, about. And the minimum wage is $7.25 federally. There are efforts in some states to increase it, and a major effort, obviously, in the news, with Congress, let's hope, considering raising the minimum wage to $10.10. There is a tipped minimum wage that you don't hear as much about, and you'll be surprised to know, and I say that sarcastically, that women are the majority of the tipped minimum wage earners. They have a floor of $2.13 an hour, with an assumption that the tips will make up the difference, and the tips often do not make up the difference. So that is just an indication of the deep poverty that even women who are working are facing. At the minimum wage of $7.25 an hour, it is $4,000 below the poverty level for a woman with 2 children working full-time. There are many women who do not work full-time, not because they wouldn't accept such a job, but because full-time hours are not available to them. So, for example, there are, in a number of industries, common practice that you are called to work for a specific number of hours that the employer has available for you, and you may not know what those hours are until the day before for the day after, nor may you know when during the day or night you may be offered the chance to work. So obviously, the amount of your earnings are dreadfully low, but on top of that, what do you do about childcare? How can you arrange childcare when your work situation means that you could have to show up at 7 o'clock in the morning one day and 7 o'clock at night another day, or no time at all a third day? And when you show up, the employer may say, I've got 6 hours of work for you today, and then be told, actually, it turns out I don't have 6 hours of work for you today. I have 2 hours of work for you today. Or I made a mistake and I don't have any work for you today at all. And this is the reality of far too many working women in this country now. So when you ask, can work be a route out of poverty, right in this moment, for too many women, work is not a route out of poverty, as much as they may try and prepare and be ready and willing to work. Now, I also want to mention just a couple other statistics, and that is having to do with the wage gap. 77 cents on the dollar is the average wage difference between men and women, and there's all this dispute. Oh, well, it's because of women's choices. It's not really a reflection of discrimination. It's really that women are, and this is the gap for women, for people working full-time over the course of a year. That gap is a reflection of women who have been in and out of the workplace, don't want to work, have family responsibilities that they want to devote themselves to. It's nothing to worry about. And I do have the pay gap for African American women is 64 cents, and Hispanic women is 54 cents on the dollar. So I guess African American women and Hispanic women really are making different choices and not at all interested in earning a dollar for a dollar, even more than white women. So all of this slicing and dicing about how many years you may have worked or what industries you may have gone into or whatever else it may be, that some might say aren't attributable to discrimination, they can't get down to nothing. Because no matter how many variables there are that you hold constant, there is still that disparity between men and women. But I would look at it in a different way. And I would say that in a certain sense, the wage gap is a measure of the economic dislocation for wage earners and burdens and disparities and discrimination that women face that steer them into lower paid jobs, that because of the absence of child care mean that they cannot be in the workforce in a steady way. The whole way that our workplace and our policies and our laws are structured get reflected, and this is for the working women, that women are earning less than men. For those who aren't working full-time, for many reasons of inability to find that work, as we discussed, or the kinds of shift work that they get, or because of large unemployment statistics that they need to combat. The gap is shown in the poverty statistics and how many more women are poor than men. So what does the law have to do with the situation? That's what we're here to discuss, and that's what Ed Sparrow would say, get on with it, okay, and we get the picture. So one of the interesting developments, and as somebody who's been working in this area for a very, very long time, you hear a lot about the women's vote, and I've heard a lot about the women's vote for a very long time. But this in particular seems to be a year where the women's vote is something that politicians are taking somewhat seriously, and there's been a discussion of the war on women. And that has come up in the last election cycles around the extraordinary restrictions on reproductive rights, which are, I think there is an element of just plain old cruelty and vindictiveness for some of these restrictions, including bans on abortion at 6 weeks. Many women do not even know that they are pregnant at 6 weeks. No exceptions for the health of the woman. And requirements that are designed clearly just to shame a woman, including these vaginal probes for ultrasounds and requirements that have nothing to do with the health of the woman and only to do with treating her with extraordinary disrespect, to say the least. Well, yes, there is a war on women in that respect. There is no doubt about it. And it has now gone from abortion restrictions also to assaults on contraception. And I hope that I can just spend a minute or two getting to that as well. But there's also now a recognition that there are economic struggles that women are facing that are, of course, interrelated and integrally related with their reproductive rights and ability to protect their health and their futures through that. But some of these issues of equal pay, of support for childcare, are being reflected in lawsuits being brought now, in laws that are being introduced in Congress, in speeches that are being made, including the speech by the president as his State of the Union this year, where the role of women and the economic struggles of women had a prominent place. And those are all things that during my now 40 years and a little more experience is not something that I have seen with such depth and frequency. And there is a real expectation, and we'll see what happens as the 2014 elections come along with more intensity, whether these debates really do come to the fore. And of course, for all of us sitting in this room, part of the answer to that question will depend on how much we insist that these debates are addressed. And it's wonderful to see a colleague like Carol Tracy in the Women's Law Project that I know is bringing up issues and working to get laws and policies in Pennsylvania and Philadelphia, and with some real movement and success. And we're seeing that in other parts of the country as well. So let me say what some of these are and some of the litigation that we are involved in also. One is the Paycheck Fairness Act. As many of you may have heard of the Lilly Ledbetter Fair Pay Act, and that was basically to restore the equal pay laws to where they were before a 5-4 decision made it virtually impossible to go to court to vindicate your rights. It was a major, major effort to pass that law. It was vetoed continuously, and it was filibustered, and it was stopped. But it was the first law that President Obama signed when he became president in 2009. The Paycheck Fairness Act would actually take our equal pay laws, and the Equal Pay Act itself was passed in 1963. It was passed a year before the Title VII, which prohibited employment discrimination broadly. And as a first step, it had many, and has many restrictions and limitations and loopholes that have been broadened and deepened by the courts over the years. So while Ledbetter brought at least the law back to where it had been, it didn't make any advances and improvements on our equal pay structure of laws on a federal basis. One of the things that Lilly Ledbetter faced was that she was working a Goodyear tire company for almost 20 years in a job that was held almost exclusively by men. She was training young men as they came along and were hired over those years. She got very good job evaluations, and she only found out after 19 years through an anonymous note that she had been paid less than every single man, no matter how new, who held a similar position in the job. Why did it take an anonymous note? Because Goodyear, like many companies, has a policy that you can lose your job if you discuss your salary with anybody else. So the inequities are designed to be kept secret on pain of firing. One of the things in the Paycheck Fairness Act would be to prohibit retaliation against employees who voluntarily discuss their salaries with others, and also to prohibit retaliation against an employee for asking the employer to do a salary survey if that employee is concerned that there may be unfairness. I thought that is the wimpiest provision I have ever heard. It's not making the employer do the salary survey, it is just prohibiting retaliation if you ask for the salary survey. And I was testifying about this in Congress, and I'm trying to make this all be helpful. I'm thinking, wimpy, but all right. You take your progress incrementally. And somebody from the Chamber of Commerce was testifying, and he singled that provision out as being a particularly problematic one. I thought, what did I miss? So, oh, I'm glad it's problematic, but what's the problem here? So the problem was if an employee asks and an employer doesn't do the survey, that could be used in court as evidence against the employer in a pay discrimination case. So there you have it for employers who might be interested in finding out. Maybe their pay isn't fair. They don't want to know. They don't even want to be asked to look. And they don't want to be put in a bad-looking spot if they are asked and don't look. So I warmed to even that provision after that hearing. But this is these are modest steps. There are also limitations and caps on the damages that you can get, for pay discrimination, in contrast to other kinds of damages and other kinds of actions that would be changed. So it's a real struggle to get the Paycheck Fairness Act passed in Congress right now. So we are continuing the fight. There'll be a vote. There'll be a hearing on the act in the Senate this spring, and there'll be a vote on the Senate floor. We are seeing some movement among some Republicans of possible interest in this. So that's a good and promising sign. One other thing, though, is that while Congress is not always the best place for action, and especially these days, as I'm sure everybody knows, things can be done in the states, things can be done in cities, and so for those of you who are here and are in Pennsylvania and in Philadelphia, you have an extraordinary ability to get state laws passed to enhance and strengthen the state equal pay laws, the kinds of remedies that are available, and that's the same for minimum wage, et cetera. There's also an effort to try to get whatever administrative action can be done, and the president said that he's going to try to get Congress to act, but if Congress can't, he's going to use, I think he said, his telephone and his pen to do what he can do. So on minimum wage, he just said that he would require any company doing business and getting contracts with the federal government to pay $10.10 in a minimum wage for their employees. And that is an important step. And we are actually asking the president to do the same thing with respect to federal contractors regarding some of these equal pay protections that are not in place yet through federal law. And I think it is always helpful, if you have an open ear, to have people who are speaking to someone who would listen. So we are trying, along with many of our friends and allies, to urge the president to issue some other executive orders and actions with his pen to strengthen at least the laws within his purview that he's able to do. So that's one thing that I think Ed Sparrow would be in favor of. I want to tell you about another new law that's been introduced, the Pregnant Workers Fairness Act. Now, one of the very first things that I was involved in when I started working in the early 70s, one of the things that was going to be able to keep me busy full time was all the discrimination against pregnant women in the workforce. And in 1978, effective 1979, we passed the Pregnancy Discrimination Act. And after a Supreme Court decision that said sex discrimination is not pregnancy discrimination, that pregnancy is sui generis, you can't compare it to anything else, so employers can discriminate against women on the basis of pregnancy and can exclude maternity coverage from health insurance benefits that they give, et cetera. Congress passed the Pregnancy Discrimination Act saying no. When women cannot work because of pregnancy, you have to treat them like other workers who cannot work because of other conditions. When they can work, you can't fire them because they're pregnant. You have to let them work. And when you are providing health insurance benefits, you have to include pregnancy-related conditions like other conditions. So where are we now in 2014? The center is getting many complaints, along with others, that have led to the Pregnant Workers Fairness Act. Women who are pregnant, and again, many women, although there are stories of women in the upper income levels, but women who are struggling with a paycheck to paycheck, truly keeping food on the table and a roof over their head for themselves and their children or their child to be. And employers are refusing to allow them to work or making even the most modest of accommodations that their physicians say they need. So if a woman is working in a restaurant as a cashier and is standing on her feet and she'd like to have a stool, there are restaurant workers, employers who have said, no, I will not give you a stool, even though they would provide that stool to employees who need it because of other physical conditions. UPS worker, and this is a case that is maybe going up to the Supreme Court against UPS, and the Supreme Court has asked for the government's opinion about whether the court should hear it, and the government has yet to weigh in, but we'll see. And this is a case where a pregnant woman was driving a UPS truck, and her doctor said she shouldn't lift more than 20 pounds of weight. And she asked for quote-unquote light duty so she could live within that restriction. And while UPS provided that accommodation for workers who needed light duty for many other kinds of reasons, they refused on the basis of pregnancy. And the Fourth Circuit held that that wasn't a violation of the Pregnancy Discrimination Act. It wasn't a violation of the Americans with Disability Act. One might ask why on either of those grounds, and that UPS was within its rights to, in essence, force her on unpaid leave. And while she was on unpaid leave, while she's pregnant, she lost her health insurance coverage that UPS provided. So she's without salary, she's without health insurance to cover the cost of the delivery. And then guess what? When it's time to come back to work, the job is gone. So they're sorry she has no job to come back to. The Pregnancy Discrimination Act would make clear, the Pregnancy Workers Fairness Act would make clear that employers have to accommodate pregnant workers to the degree that they accommodate other workers in the workplace. So I frankly thought that was a box that we checked off in 1978, but it appears that we still need to be fighting some of those fights, and it is off the charts popular with the public. So is the Paycheck Fairness Act, and so is raising the minimum wage. So we have a lot of equities on our side, and we have a lot of public support on our side, so we just somehow need to get mobilized and push those policymakers and to make a difference. And you may say, what about judges? And sometimes those judges will get it wrong, and you can correct what they're doing. When it's a constitutional decision, that becomes a little more tricky. But I also think that judges are a product of their own experience and what they see. And when they decided the Ledbetter decision, and there was such a furor and became such a big political issue, Ruth Bader Ginsburg in a few public forums said that they were taken aback. Now, she, of course, wrote a dissent, and said that that decision reflected a lack of complete understanding of the way the workplace worked and was devastating to women's equal pay rights. But they were really, she said, the justices were very surprised at the public reaction. So when some other decisions may come down that perhaps the justices thought, oh, well, this may be within the bounds of what the public could accept, they too, in some indirect ways, sometimes can reflect what are societal norms. And so again, the work of all of you who are interested in the public interest and in poverty and living out Ed Sparrow's principles, you have a lot of tools at your disposal to make a difference directly and indirectly. And I will say, even not in a public forum, but through policy and law, but the Gap, for example, just announced that it was going to pay the minimum wage of $10.10 an hour for all of its employees, and that it saw that as good business. And so there are many ways, while trying to make changes through the law and through the public forums that we have, to change private behavior as well. And I am just have a few more minutes, and I wanted to cover another case that's in the Supreme Court this term as a reflection of what's really going on, of why women's rights matter to the economy, to the future of the country, and to women's ability to escape poverty. And that's the Hobby Lobby case. And there's also a Conestoga Woods case that came from the Third Circuit that the Supreme Court is considering, and there's oral argument scheduled for March 25th this spring. Well, these are cases that come out of the Affordable Care Act, and George very generously gave me some credit for a provision in the Affordable Care Act that actually was sponsored by Senator Barbara Mikulski, and that required that some of the incentives that are built into the Affordable Care Act to cover essential preventive health care, to ensure that they be applied to essential preventive health care for women, that HHS set up a process to specifically determine what would be essential preventive health care for women. So the Institute of Medicine held some hearings. I'm proud to say we participated, the center, in those hearings, and came up with a decision accepted by HHS that contraception is an essential preventive health care benefit for women. And the evidence is overwhelming around women's health and why contraception is so important for the ability for women to space children so that they themselves can remain healthy and so that they can have healthier children. And that, of course, doesn't even get to the question of women who can't get pregnant because of health conditions they may have, or the need for economic security for women to be able to continue their education, stay in the workplace, be able to support the children that they have, to be able to chart their course of life. Contraception is essential, and the Institute of Medicine, going through a long and quite detailed set of findings, came to that conclusion. There was a lot of pushback by some religious institutions that had argued that we have deep moral objections to contraception. And we cannot tolerate covering contraception and providing that coverage as part of the employer-provided coverage that we give to our employees, regardless of how many employees we have, regardless of whether they have any religious beliefs in sync with ours, regardless of the nature of the jobs that they are holding in our companies. They may be janitors, they may be housekeepers, they may be cafeteria workers in hospitals, but we have a strong belief, such a strong moral belief and religious belief against contraception that we cannot include it in our health insurance plans. To tell you an interesting development in the law, and the center had a little bit to do with that, I'm proud to claim as well. In the year 2000, the Equal Employment Opportunity Commission that enforces and interprets Title VII said when an employer, under that Pregnancy Discrimination Act that passed in 1978, when an employer provides health insurance that covers a broad range of health needs and prescription drugs, it can't exclude contraception because it is covering all the prescription needs that its male employees have, but not that its female employees have. That's a diminution in women's pay. That is discrimination on the basis of the benefits that women get when they are working on the job. And there hasn't been a whole lot of litigation in the area, but Title VII doesn't have an exception for religions to pay women less on the basis of religion. There had been a case that was decided in the Ninth Circuit, it didn't go any further, about a religious employer who believed that men are the head of the household. That was part of their religious belief. So they would give health insurance family coverage for male employees, all male employees, married or not, and single women who didn't have families. But if you were a married woman, then your husband was the head of your household, not you, and you do not get family coverage from this employer. Well, the Ninth Circuit said that may be the religious belief of this employer, but that happens also to be sex discrimination, and that employer has to provide family coverage for its employees. Well, now we are in a situation where nobody's questioning the religious belief of the employer, but what does that have to do with the employee, and how does the employee's rights to pay what they are working for and pay, and their health needs and their future prospects get factored in? And all of that is going to be decided in this Hobby Lobby case in the context of two for-profit corporations. The Obama administration decided that for houses of worship, they would be accepted altogether from the requirement. If you were a religious nonprofit organization, like a religiously affiliated school or hospital, you yourself didn't have to provide the contraceptive coverage, but your insurer would have to pick it up. So the women would get it, but not from you. There are challenges going on, by the way, to all of those. But Hobby Lobby and Conestoga Woods deal with for-profit corporations who say that their owners, even though they have incorporated, have religious beliefs that need to be protected and trump the religious beliefs of their employees, who may feel that it is the right and principled thing to use contraception, let alone their health or future. So the technical legal issues before the court, a lot of deal with whether or not there's a religious freedom, RFRA, Religious Freedom Act. I wrote down the actual name. I never can get RFRA's real name. And it prohibits the government from imposing burdens on persons in the exercise of their religious beliefs unless the government has a compelling interest in doing so and is pursuing the least restrictive alternative in pursuing that compelling interest. So the question is a for-profit corporation a person that can have religious beliefs. And so there's a lot of attention being paid to whether, when the whole point of incorporating is to separate out the corporate entity from the individuals behind it, so that there are limitations to liability, there are different standards for criminal liability and civil liability, but can a corporation have the religious beliefs of an individual? That is the fundamental first question, and there's going to be a lot of attention paid, and in the briefs paid to that issue, and properly so. But we filed a brief, and we focused on behalf of 70 organizations, and we focused on a separate question. If the court gets over, and some courts have gotten over, not the Third Circuit, by the way, who found against Conestoga Woods, but Hobby Lobby won in its circuit, so there was a split in the circuit. So the question is, if a corporation can be, a for-profit corporation can be a person that can exercise religious beliefs, and this would be the first time that that would ever be found in the law today, with quite extraordinary implications, actually, then is the provision of contraception and the promotion of women's health and the facilitation of their educational and economic futures a compelling interest of the government. And we have cited many decisions where government policies and statutes that have promoted those interests have been found to be compelling. If this Supreme Court were to find that women's access to contraception facilitated by this provision for the Affordable Care Act is not a compelling interest, governmental interest, that would really be quite devastating with extraordinary implications, very broadly in potentially in their reach. And so it's a case that I really wanted to spend a couple minutes highlighting and alerting you to as we see what happens as that case is argued. There are a lot of plans afoot, and I know the Women's Law Project, among others, will be participating on March 25th with many religious leaders and all kinds of other organizations speaking out on this very issue of the critical nature of contraception for women and the economic implications to women and their ability to escape poverty that are so intertwined with this access to contraception. So there will be many opportunities to speak out and to make your voice heard around this issue. There will be many policymakers listening to hear who does speak the loudest and what are the arguments and who is speaking. So like virtually everything else I've been talking about, this is one where your voice can really, really matter. And if you want more information, nwlc.org is a place to go. And Carol, if you want to say what the Women's Law Project's... Okay, another tough one to remember for what may be going on right in this vicinity. Then we urge you to get engaged. So I know that we were trying to leave a little bit of time for questions, and I don't know if I've overstayed my welcome or if there's time for one or two.
You didn't overstay your welcome. I think we're going to move on to the question and answers.
Well,
We'll have plenty of time in between panels.
okay,
Certainly didn't overstay your welcome.
I'm sorry that I took up the question and answer period with my proselytizing to you, but I couldn't feel more strongly about the power that's in this room, and my hope that you will harness it in a way that I believe would make Ed Sparrow proud. So thank you so very much.
I think Ms. Greenberger is probably the last person that could possibly overstay her welcome at the University of Pennsylvania Law School. So thank you so much again, Ms. Greenberger. It was wonderful. What